This is Good Evening San Diego.
A lot of people reacting today to the state of Georgia issuing that federal indictment against former President Donald Trump and 18 others over their alleged efforts to try to overturn the 2020 election loss there in that state. Central to these charges is the RICO Act. You've probably heard of it. It was adopted back in 1970. It's the Racketeer, Influenced, and Corrupt Organizations Act. It makes it a crime to participate in, acquire, or maintain control of an enterprise through a pattern of racketeering activity or conspire to do so. It was used against the mafia. That's how most people know about this. So joining us now to talk a little bit more about it is criminal defense attorney Vikas Bajaj. Great to see you, Vic.
Likewise, thank you.
So this was kind of a little bit of a surprise. The president being indicted on 3 separate occasions. Now this is the 4th. We've got 18 others, and they bring up this RICO statute saying that it was kind of this criminal enterprise, criminal organization. What do you make of this?
Well, you know, the world of criminal defense or prosecution on both ends, both state and federal, and here we're talking about a state case brought by the state of Georgia. We have single defendant crimes. Then we have, on another layer of complexity, conspiracies, 2 or more people who agreed to a common goal of criminality. And then you have the big whammy in both state and federal courts, which is RICO. Now, why is RICO such a big thing? It's usually used against organizations like crime families, criminal street gangs, ongoing white-collar fraud to defraud the United States, for instance, with Medicare fraud, or even school districts pumping up the scores that they have on their school tests to get more funding. But these, if you look at the history, Logan, are long-standing institutions. Here we have a RICO allegation levied against a very short-lived institution that is post-election, post-loss, up until around January the 4th. If you look at the overt acts, so every time a prosecutor says there's a criminal action in either a conspiracy or a RICO act, there have to be certain acts taken in furtherance of that enterprise's criminal activity, and these are called overt acts. Well, in this case, there's no less than about 170 of these overt acts, and if you actually dissect them and you peel off a few layers of the onion, you'll come to find out most of these overt acts, if not 90+% of them, come just after the election and ending just around the beginning of January. So this is a very short-lived enterprise, as the state of Georgia is calling it, which I believe is going to be ripe for significant challenges. No matter which side of the aisle you stand on here, Logan, you have to have a right to due process. So I would predict, and I'm sure the defense attorneys are already on this, a significant investigation of the legislative history to determine what it was that the state of Georgia in 1980, when they enacted the RICO statute in the state, were trying to attack. And my gut feeling says once that inquiry is done, it will be organized criminal organizations such as criminal street gangs, mafia gangs, as we see in the 1970s, as you alluded to, really spearheaded by Rudy Giuliani. It just doesn't seem to fit, and I think it's going to give rise to constitutional challenges.
Does it sound like maybe they can't prove that this was a long enough enterprise? It didn't go on long enough. It just happened maybe within a few days, even though they could maybe show that there were enough of these overt acts to show some kind of criminality and agreement?
Well, that's exactly what it was. I mean, you can tell that if there was an agreement before the election results were made public to everyone around the world, that those would be some of the overt acts that would be pled in this case. That's clearly not a step even that district attorney in Georgia is willing to take. What she is willing to say is immediately after the election, there should have been some sort of an epiphany to Donald Trump and his legal team to say, you know what, we should concede right away. The problem is many of these overt acts, as I indicated, are there before judges and courts had actually had finality or decisions on the righteousness of the election. I think that makes it ripe for legal challenges.
Do you think the other states that filed an indictment against him might amend it to bring in RICO, or do you think they thought about it and thought, well, it's too difficult to get RICO, we'll just stay with what we have?
You know, RICO is an interesting statute. When defense attorneys, from our point of view, when we are conquering or defending against a RICO statute, it's really a story that's being told about our client, a long story, a book with many chapters. Prosecutors generally, especially on the state side, do not like alleging RICO because you have to prove the story. It has to be a convincing story. Sometimes one would argue that state prosecutors are much better served by charging a simple conspiracy or single criminal acts, which we also saw in this indictment.
Sure, that could just be simpler is what it sounds like. All right, Vikas Bajaj, great to see you, Vic. Thanks
Likewise.
for providing some insight into the RICO statute.
Thank you.